should focus on the definition of harmful interference in international law, its technical types, and etc. Harmful interference is a special part of international space law. It is not regulated UN bodies at all. For example, we can say that outer space T, the LTS guidelines, they have provisions about harmful interference, but the International Telecommunication Union is an international organization which deals with harmful interference reports. In case of ITO, they have own constitution and they have rather regulation, and I'm going to focus on them as well. According to ITO, harmful interference is a interference caused by electromagnetic waves within similar bandwidths that could make receiving and decoding multiple signals impossible. HI, namely harmful interference, may take three forms: electronic interference, such as notably biorelatives, kinetic interference, which emerges by way of physical collisions, and interference of satellite communication activities. Usually, harmful interference when antennas are not readjusted correctly, or there is a mistake in calculation of transmitting carriers, but it's a special case which demands plenty of investigation and plenty of fixing key international binding documents, it's which deals with HI. It's about Outer Space Treaty, particularly Article 9, the ITU Constitution, Article 56, the ITU Constitution, ITU Convention, and the radio regulations, especially Article 15. According to radio regulation 34, definition of HI is noted as it's a kind of case when all stations are forbidden to carry out unnecessary transmissions, or the transmission of superfluous signals, the transmission of false or misleading signals, or the transmission of signals without identification. Usually, when signals are not identified, I mean, there's of a source of are not identified, it really becomes difficult to determine which organization or sends these signals, because when according to ITU rules, when satellite administrator, administration of satellite operator determines harmful interference, it should inform another satellite operator, suspicious another operator, or ITU as well, and you have to specify precisely all details of harmful interference case in your filing. But right now I would like to focus on how to deal with, or what kind of options should be developed in international space law in order to avoid harmful interference and to solve harmful interference disputes more peacefully. For example, Outer Space Treaty, Article 9, it simply implies a duty to consult in good faith. However, it does not even include a duty to prevent or suspend activities that encompass interference in their impact, or other countries' satellite operations. It stipulates due regard for the space activities of other states. Due regard is the international, in general, it's a principle of international space law, and particularly this treaty which demand to continue to consult, to continue to negotiate when there is a dispute. And then later, I should say that According to I2 constitution, as they specify that any associated orbital position in the geostationary satellite orbit, or any associated characteristics of satellites, the orbits, in order to harmful interference between radio stations or different countries, should continue consultations and should continue adjustment of radio frequencies. I have noted only a few abstracts, few excerpts from I2 Constitution, which dedicated to technical and legal legal position, how to solve these disputes. Later, so in this regard, I would like to generalize and to introduce you I2's position on HR disputes. As we mentioned in the Article 56 of the I2 Constitution, it deals with specifically harmful interference between satellite operators and etc. And they suggest and they actually demand and stipulate to solve this dispute through negotiations, through diplomatic channels. They stipulate bilateral or multilateral treaties. They have recommendatory guidelines and handbooks of I2 board. They also stipulate space monitoring, drafting reports and cooperation agreements with various states. They have a special satellite interference reporting and resolution system, and they have optional protocol on the compulsory settlement disputes relating to the HI. But the issue is that none organization has ever relied on, counted on this optional protocol. On the other hand, there is also liability convention, which adopted in the 70s years, but this liability convention does not deal with harmful interference disputes. To several experts in space law, for example, Mr. Ben Cheng, Professor Ben Cheng, time noted that a liability convention is on can deal with can solve disputes only physical damages, not electromagnetic damages. However, several experts claim that no, harmful interference also should be included into sphere of a liability convention, and it's also disputed. Therefore, I cannot personally claim that we can consider liability convention as one of the main sources, main legal documents for solving such disputes. Later, I would like to focus on what lacks in such, in general, in international space law. I mean, in ITU documents and other UN bodies documents. For example, they are not flexible and time-consuming, having effective results during negotiations, because you are not, you should be ensured that the party which you are dealing with, you are negotiating, they are doing in good faith, or they will come up with a certain decision. And of course, there's also bureaucracy in quasi-judicial settlements and diplomatic channels. Quasi-judicial settlement means any kind of dispute settlement which demand and stipulate participation of diplomatic channels, like Ministry of Foreign Affairs, I don't know, maybe embassies and etc. And usually also we suffer from deliberate avoidance by satellite operators. And on the other hand, how to define the amount of damages for the interest of both parties. For example, if a victim party, let's say, wants to demand compensation from tortfeasor, satellite operator, how to calculate the damage, it's also a huge gap in international space law. There's also a insufficiency. It's about vague norms. For example, according to Article 9 of the Outer Space Treaty, it stipulates that in case of harmful interference, parties should do international consultations, which I have mentioned below. Of course, it's limited because a party, a settled operator, which submits a filing about harmful interference, they should specify and they should have somehow convince that yes, indeed there is a violation of electromagnetic waves by another satellite operator. They also may request consult concerning the activity or experiment. So it's a kind of issue. The consultation is a duty or it's a right. I mean, what if another satellite operator, if your country refuses to continue consultation? Please excuse me. Later, one of the suggestions which I would like to, focal points of my suggestions on behalf of Other Cosmos, what I would like to add. It's about third party or settlement dispute methods. It's about free choice and flexibility in dispute resolutions. Of course, it's about to develop a special mechanism which helps to act in the next stage when there is a breach of duty to consultate and negotiate. And there is and we eliminate the risk of a double restore or forum shopping, revising a claims commission and set up certain deadline. Claims commission, it's determined by liability commission in all kinds of dispute settlements between satellite operators. However, as it is uncertain whether liability convention should be included. I mean, harmful HI included into liabilities conventions area, of which convention is supposed to be solved. It's a little bit uncertain in the international space literature and space law. On the other hand, we should recognize due diligence, standard of care in a disputes, which is a definition in tort law or in delicts law. I mean, it's a kind of principles of civil breach rights of civil breach of civil rights of parties. Recognition of HI as a transpondary harm and providing prompt and adequate compensation mechanism by ITU. It's a little bit idea which I am claiming, but it's necessary, completely necessary. As because usually telecommunication setup operators like Other Cosmos, they have problems with calculating damages and demanding compensation, fair compensation, and usually demanding fair compensation, calculation, and precision of the damage, amount of the damage takes much more time and much more resources for telecommunication setup operators. Therefore, any kind of international body like ITU, I don't know, maybe International Space Organization, which can be established by international space community in the future, they should deal with such administrative problems. On the other hand, we can suggest that yes, serious adaptive sanctions, they fall in shortage in international space law, especially in HR dispute. There should be reduced quasi-judicial dispute settlement methods. And finally, I should note that good faith in negotiations, it also needs to be focused on specifically, because usually when a filing has been submitted to the ITU special committees, they demand explanation, clarification from the tortfeasor asset operator, and but you are not sure whether their report is falsified or it is contaminated because there is no any kind of international organization, including who has empowered to verify correctness of reports which has been or may be given by a violator set operator. And I would like to focus on radio regulations, which is indeed the constitution of Hall interference. They have, I mean, they has noted special statements and articles in order to avoid interference, which their terms indeed are vague and uncertain. For example, locations of receiving stations shall be selected with particular care. What means particular care? It's in international space law or in ICOMS. It has never been explained correctly and precisely, actually. For example, in Article 15, they also have a special provision such as radiation in exception from unnecessary directions shall be minimized by taking the maximum practical advantage. Unfortunately, the explanation of the disclosure of maximum practical advantage has never been cleared in the recommendatory guidelines as well. And finally, I would like to focus on section 6, where it shows that administration having jurisdiction over the transmit station whose service is being interfered with shall inform the administration having jurisdiction over the interfering station, and giving all useful information in order that this administration may take such steps may be necessary to eliminate the interference. It's also a kind of vague and unclear statement. For example, in this section, I mean, in radio regulation and in their recommendatory guidelines, has never focused on what means necessary steps in order to eliminate I mean, it's a kind of mixed steps which should be concentrate on in future. It's a kind of each issue. It is emerging space telecommunication satellite operators, so they demand. I also would like to focus on transparency in lack of transparency as well. For example, section 4 of the regulations, they they said in order to avoid harmful interference, taking of all possible precautions such as the choice of frequency and of time and the reduction. For example, what means possible precautions? It's also demands juridical and technical explanation, and there is also a special statement which needs to be articulated correctly for the interests of telecommunication satellite operators, when it implies that signals for testing and adjustment shall be chosen in such a manner that no confusion will arise with a signal. What means in such a manner? It's also vague. Ambiguous term, which I would like to focus on these, I mean, ambiguity of these terms, because these terms always may mislead negotiations and consultations into a catastrophe. They are reasons which enable violator setup operators to avoid consultations and negotiation. Finally, I would like to focus on concluding remarks, which may be useful, or actually can be useful if they are focused on good faith in due diligence. For example, duty to ensure prompt and adequate compensation should be part of international customary law. Duty to ensure prompt and adequate compensation it comes from international law, especially when there is a pollution of oceans and seabeds, rivers, and etc. But unfortunately, it's not a norm which has ever recognized by international customary law. I mean, such as International Court of Justice and etc. And on the other hand, not having customary rule, I mean, peremptory norm on state liability should not mean that will not be obligations. In this case, if a water is a private company, it doesn't mean that corporate liability, satellite operator is limited. State is also liable for HI cases such as private companies. But if we want that private space actors develop activities in commercial space sector, state liability and the private liability should be adjusted. Nevertheless, according to Mr. Ram Yaku, who is a professor of McGill University Air and Space Law Center, according to him and according to Professor Stephen Freeland from Australian Southwest University, they identified that there are no private space activities. It's all state liability because space liability demands, space activity demands licensing from states. So if a state gives license to a private space actor, so it means that state institution and private organization, they share liability in their outer space activities.